Morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Michael Hall. Here. Kyle Holland. Here. Joshua Morgan. Gary McKeever. Chase Harrison. Bradley Bearden. Here. Sherry Roach. Present. Yeah. Thank you, Mr. Lawhorn. James Arnold. Here. Billy Autry. Jody Denton. James Grossel. Grossel, is it Grossel or Grossell? Grossel, thanks. Randall Halbert. Here. Miranda Hatton. She'd say when she's going to be here. Ronald Limbaugh. Shane McLeod. Linda McFerrin. Jarek Chase Munns. CR 25-100, CR 25-237. Have confirmation that he is in custody. Do not know his location. Could be federal custody. We will recall that. Eddie Pate. Gina Prox. Patrick Rowe. Junior Spence. Martin White. Sean Nunez. Vincent Offord. Thank you. Is it Ms. Muir?
Yes, Your Honor.
All right, thank you. And Mr. Offord's here, correct?
No, not.
You know where he's at?
I'm stuck on something.
David Ray Carley, CR 24-179. Thank you, Mr. Carley. Mr. Thorson filed a motion for continuance, I believe, and that was granted. I'm going to have you in just a moment. I'll call you up and we'll have you sign a notice of appearance, and we'll get you reset to your next date. Jace Quaid. All right, same announcement for you, Mr. Quaid, on Mr. Thorson. We'll bring you up shortly and get you reset. James Fontenot. This is cause numbers 2025-346, 2025-425, CR 24-258. We have documentation that Mr. Fontenot is in the hospital. We'll recall that case. Gilberto Jimenez. And Richard Strange. All right, is there anyone who's in the courtroom and your name's not been called and you expect to be on the docket? All right, I see no one. We have any counsel that's ready? Mr. Lawler, you ready?
Yes, Your Honor. Thought about it, Ms. Jerry Roach.
All right, Ms. Roach, if you'll come forward. This cause number CR 25-213, State versus Sherry Raylyn Roach, and Ms. Roach is set for pretrial. Any announcements?
Yes, Your Honor. First, my son, my 9-year-old son, took my briefcase to school this morning with him.
Was it for show and tell? Yep.
Sort of, been an issue. So I'm working on that. So I'm going to use this from memory. The state and I conferred yesterday. This case has some voluminous discovery. It's a banking records driven type case. We're having financial analysis done. I'm asking the court to consider giving us one more status. Beyond that, the state is also tracking down some possible additional discovery that I don't think they have. They have sought some PayPal records. We don't have those. They're looking for those. So we're just looking for.
Do you think 30 days will be enough?
Well, if we end up getting the forensic accountant done, he says he would not be able to get to it until January.
And are you anticipating needing all of the records to make a determination on whether or not you need to file any contested pretrials, or is that just for trial readiness?
Nothing dispositive, Your Honor. This is really, in terms of trying to what happens on potential restitution, if that becomes an issue in the case. Don't know that yet.
Okay. I've got a few dates in January. Got January 6th, 8th, and 20th.
The 20th, works for me.
All right, court says Ms. Roach for additional pretrial, January 20th at 9 AM. Once she signs her notice of appearance, she's free to go.
Thank you, Your Honor. After that, maybe we'll see.
Yes, thank you, Mr. Lawrence. Good to see you. Good morning. Your name?
My name is Stuart Parkinson.
Okay. All right, Chase Allen Harrison, CR 25-131, and we are set for pretrial. Go ahead, Ms. Harkins. Dave?
Yes, Your Honor, we've been having some difficulty with some of the videos. They're a little bit older, so getting them into proper formatting. Believe we've gotten some of the videos to work properly. I'm hopeful that I've gotten the rest of the videos to work, but as of last night, they were still kind of processing. And we're tracking down some other alternative ways if my solution doesn't work. All that to say, we've made some progress, but we are still working on getting all of the videos to work properly.
How long do you think it'll take to get the defend all of the discovery?
Your Honor, we should be able to have it hopefully by the end of next week.
All right. Are you familiar with Mr. Griffith's calendar?
Yes, I am.
All right, so I've got those dates in January the 6th, 8th, or 20th.
January 20th.
Court sets Mr. Harrison then pretrial January 20th at 9 AM. Once he signs his notice of appearance, he'll get the yellow copy, white copy stays here, and he'll be free to go. Yes, you're excused. Thank you, Ms. Harkins. Sure. Good morning, Mr. Head. I'm great. Are you ready on Mr. Beard? Yes, sir. Bradley J. Bearden, CR 25-195.
Your Honor, we are set for pretrial. I've had some issues. My emails on the status. Governor, see it, so maybe it's all the issues. And we could, do not expect the discovery in this case to be very luminous. Pretty basic. If we could get a reset, I think we can give the state to make sure that we see the discovery.
State, can you look up to see if the discovery was provided?
Yes, Your Honor. I managed to see this yesterday. I'm not exactly sure what's going on with Mr. Head's email in the portal. I was under the impression that this had already been communicated, but apparently the discovery was sent to Mr. Weiner's email since they're partners. But if that doesn't work, we will get on it to figure out whatever's going on with Mr. Head's access.
So you're showing that it was sent to Mr. Weiner, not Mr. Head.
Yes, sir.
So can you just send it to Mr. Head?
We can certainly work on trying to figure out whatever the issue is. I don't know why Mr. Head's email isn't working with the portal. I thought that was an agreed resolution from the notes, but if it's not, we will absolutely get with LGS and make sure that Mr. Head's email is working properly.
So y'all have been working on this for quite some time?
As of yesterday, Your Honor, that's when I looked and read the note. I believe it went out after the arraignment setting, so about 30 days, but I couldn't tell you from memory when the note was put into the case file.
All right, Mr. Head, you want the sixth, eighth, or 20th of January?
The eighth should be good.
Eighth?
Yes, sir.
All right, court sets Mr. Beard for additional pretrial, January 8th, 9 a.m. Once he signs his notice of appearance, he's free to go.
Thank you, Chairman.
Good morning, Mr. White. All right, who are you ready on first, Mr. White?
We can take care of this straight.
Richard Thomas Strange. CR 25-104. Mr. Strange is set for docket call today. Go ahead.
Gonna add, that is January 8th.
Is there a reason you can't announce today, or what's the reason we need to reset?
It will set it, please.
Oh, we're safe for plea. I thought,
Yes,
okay,
January.
I thought you said reset. Okay, January 8th for plea. All right, court sets Mr. Strange for plea, January 8th. Will that be a morning or afternoon plea?
It was
It'll be at 9 a.m. Which like next?
let's address Mr. Bond's situation.
Court calls State of Texas versus James Owens Fontenot, CR 24-258, 2025 425, 2025 346. Set for docket call today. I understand Mr. Fontenot's in the hospital. Any updates?
Your Honor,
You can. Mr. Fontenot is at the hospital at this time. Reset docket call on January 8th. Roberto Mendez, CR 24. Waiting. Search.
It did, it was released, Your Honor, and it was dispositive to our case. So at this time, the state will move to dismiss those matters. If I may approach the bench.
Yeah, please. And if you don't mind, I'll just summarize what we're doing.
Your Honor, my understanding, the issue was whether or not the dog, the narcotics dog, actually intruding into the inside of the vehicle constituted an illegal search for purposes of building probable cause. The court found that it was in fact an illegal search because the dog broke the threshold of the door, went inside, and then sat down to alert as to the presence of narcotics.
Very well. All right, thank you, Mr. Hernandez. All right, the state having tendered motion. Causes the court to fight against the state's motion. Yes, look at your cases. Jesus, gift that you received in your life. Think about if the court would have ruled the other way. Very serious felony offenses. So. Case is dismissed and you're free to go. Training, good morning, sir.
Morning, Coach, how are you?
Start. Who are you ready?
Ready to start on Mr. Billy Autry.
Mr. Autry. This is cause number CR 25-161, 5-1, state notices. Billy Autry, and we're set for docket call in all cases. Go ahead.
Yes, Judge, we received offers in these cases, however, I provided the state some information regarding their paying witness that I asked me to give them a chance to reconsider the offer and negotiation of this case.
Any objections from the state?
No objection, Your Honor.
All right, court will set Mr. Autry for a final docket call. You want that eighth, January 8th. Looks like that's only Thursday, January. Otherwise, I could move you to February 5th.
Judge, if we can do February 5th, I believe I'm trial on.
All right, court sets Mr. Autry then for final docket call in all cases February 5th. And on that date, he can tell the court if he wants a trial or if he wants to plea negotiate.
Yes, Judge.
Who's next?
Judge, next I have Ms. Jody.
Jody Lynn Denton. This is CR 25-145, set for pretrial.
Yes, Judge, we have a motion to suppress on this issue. We request we set on the evidentiary contested motions. I have not filed that motion to suppress, but I have on the state note that our intent to file it before the contested motion.
Any objection from the state?
No, Your Honor, just as long as I have enough time to review it, to know that which witnesses that I need to have.
Court will set Ms. Denton then for January 22nd on the motion to suppress. If that motion does not get filed, then that will become a docket call.
Yes, Judge, and I will have it filed in sufficient time for the state to consider.
Who's next?
Judge, next, Mr. Russell.
James Chandler Grossel, CR 25-202. All right, Mr. Grossel is set for pretrial.
Yes, Judge, we are call on this case. And Judge, we would ask that whatever setting we are given, Mr. Russell is going into the hospital for treatment, I believe, at the end of this meeting.
Yes.
And he's providing documentation of that, provide that to the court as well. We ask that he needs to be allowed to appear via Zoom or have a longer setting.
All right, court will set Mr. Grossel then for docket call February 5th. That'll be at 9 a.m. And Mr. Grossel, before you leave, I need you to check in with the court's pretrial release officer, Mr. West, and sign your conditions of pretrial release before you leave. Okay. As soon as he's done, yeah, just. Mr. Grossel, you can just come back here. This is Mr. West. He'll meet with you on your pretrial release conditions and then you'll be free to go.
Yes, sir.
Who's next, Mr. Manning?
Judge, next ready on Randall Halper.
Mr. Halbert, CR 25-203, State versus Randall James Halbert. All right, Mr. Halbert, set for pretrial.
Yes, Judge, there's no, that's the pretrial issue this time. Set on Dr. Collins.
All right, court will set Mr. Halbert for docket call February 5th at 9 AM. Once he signs, he's free to go.
Judge, Mr. Limbaugh.
Ronald Lynn Limbaugh. This cause numbers CR 25-210, CR 25-211, CR 25-212. Mr. Limbaugh, set for pretrial in each case.
Yes, Judge, no contested pretrials at this time. Request to be that.
Court sets Mr. Limbaugh for docket call February 5th in all cases at 9 AM. Mr. Limbaugh, while Mr. Manning's filling out that form, I show that you are delinquent on your pretrial release fees. When's the last time you made a payment to your
What
pretrial?
happened, last couple of months, or
Yeah, that's okay with me. How much are you paying today?
what,
My records say 360.
that's what I'm like.
All right, I'm gonna write that down and hold you to your word, okay?
Yes.
All right, thank you, Mr. Limbaugh. Who's next, sir?
Judge, next ready on Ms. Barron.
Linda Mabry McFerrin, CR 25-151.
And Your Honor, I don't mean to cut off Mr. Manning. I didn't have a chance to talk with him beforehand. We actually received information from a complaining witness. State will be moving to dismiss the case today. And I'll have a written motion for the court.
So you're making an oral motion to dismiss that I can roll on now, and then you'll follow it up with a written.
Yes, sir.
All right, then the state having made an oral motion to dismiss, the court will grant that motion. Ms. McFerrin, you're free to go. Who's next?
Judge, Mr. Clemens,
Let me call it on record. This is cause number CR 25-100, CR 25-237, State versus Jarrett Chase Munns were set for arraignment in the CR 25-237 case, docket call on the other. I do have confirmation that he's in custody. I do not know his location. Any updates?
Judge, the only thing was I was going to file a motion to withdraw on his bail judgment case. have with his federal custody, I don't know if that's be necessary any longer. So if we just want to hold over his cases until we have further confirmation of this.
And I don't know if it's federal. I just don't know where he's at. I just know he's in custody, which tends to be a federal marker.
Judge, my understanding was that he did have a federal case pending. He had a pretrial hearing. It was supposed to be set after our pretrial hearing last date. Obviously, he didn't get that. So I imagine that's what he is.
All right, court will set Mr. Muntz for status on custody February 5th. We'll see if we can get some more information. And State, if you can assist in that as well, that would be appreciated.
Yes, sir.
February 5th at, we'll set that at 1:30.
Yes, Judge, and I don't know why it shows that he has personal bond on there, but my understanding is that his previous bond was revoked and he is not going to give it a bond.
Yes, sir. Yeah. Would. Just me. Who's next?
Judge, we may have just one with the state.
Yes, Phil.
Yes. Judge, next ready on Miss Rocks.
Gina Lynn Prox, CR 24-220. All right, Ms. Prox is set for docket call today. This is also cause number CR 2422. Go ahead.
Judge, we request reset the same announcement as we made previously.
Reset for, I'm sorry,
For document month,
for what reason?
we're waiting co-defendant's trial.
Okay, sorry, I don't retain a lot of the
Yes.
co-defendants from month to month, so, all right,
And
we'll reset,
And Your Honor, just by, for the court's information, the co-defendant, he's not special set for, the January trial, but I think he's,
Number one on the rolling trial document.
right.
Is this the one that I pointed Mr. Wood on?
Yes, sir.
All right, we'll reset, Ms. Prox then to February 5th. Docket call. Ms. Prox, my records say that you're delinquent on your pretrial release by about $90. When's the last time you made a payment? How much can you pay? How much can you pay today? Okay, so I want you to go do that today, okay?
Yes.
All right, Mr. Mayor.
Judge, next, we would call Junior Spence.
Junior Lee Spence, CR 25-103. All right, Mr. Spence is set for docket call.
Yes, Judge, we requested a reset for this, we provide the state information regarding the complaining witness, as well as what we requested the criminal history of all witnesses for the state. We're still waiting that information. That's a reset on the docket call.
Steve?
Your Honor, we're working on getting any, civilian witnesses together. I know complaining witness, has some business of her own. I know we were gonna see how that might unfold. So if we could get a reset just to kind of see where things go with that.
All right, court's gonna set Mr. Spence for a final docket call February 5th at 9 a.m. And Mr. Spence, have you signed your conditions of pretrial release yet, Mr. West? Okay, you need to do that before you leave today. I'm gonna order you to do that when you leave. Have a seat in the hallway and Mr. West will come find you. We'll go over your conditions, have you sign it, get a copy of it, okay?
Just for Josh, what
Are you ready?
yes, Judge.
Mr. Morgan, Joshua David Morgan. CR 22-279, CR 22-309. All right, the court finds that Mr. Morgan was placed on community supervision by this court. The state has filed a motion to adjudicate Mr. Morgan's guilt. Court finds that he is indigent upon his application for court-appointed attorney. Court hereby has appointed the Honorable Jonathan Manning. And the court hereby sets Mr. Morgan for a hearing on the motion to adjudicate January 22nd. On a
Judge, I believe that's all I have ready at this time.
Okay.
Paperwork.
Yes, yes, sir. Ms. Muir, have you heard from your client?
He's still waiting for attorney. Maybe
let's wait for all that. How far away is he?
That I'm not sure because he's still waiting on someone to get there.
He didn't tell you where he was though.
Somewhere else to be.
It's up to you, Ms. Mayor. My docket will end at noon, so we can either wait for him or I can find his bail insufficient and he get rearrested and bring him to court that way. It's up to you. What do you want to do? Okay. I bet you do. Yeah, just let me know. Just check back in. You're welcome. Mr. Bratton, you ready on Mr. McKeever? All right, Gary Raven McKeever, CR 25-81, and Mr. McKeever is set for final docket call today. Go ahead.
I think the plea bargaining processes come to the end of the agreement on that. So we'll see.
All right, what offer was extended to Mr. McKeever that he's rejecting?
Well, it was an 8-year deferred. Last time we talked, it was made a conditional some kind of evaluation offer. So I'm ready.
And your client understands that the court may not allow him to negotiate this case once we place it on the trial docket. If he says he wants a trial, he gets a trial. He understands that?
Yes, I bet.
All right. And so he's rejected the 8-year deferred community supervision offer. All right, court will place Mr. McKeever on the trial docket. This is a sexual abuse, continuous sexual abuse of a child under 14 years of age, first-degree felony. Is that correct?
That's correct, Your Honor.
All right, Mr. Brett, what I'm gonna do is I'm gonna specially set Mr. McKeever for trial. He'll be number 1 on August 31st of 2026. I'm especially setting him because he's accused of a sex crime against a child. But what we're gonna do is Mr. McKeever is going to report to the court for check-in with the court's pretrial release officer and to sign a notice of appearance. He'll do that monthly, beginning January 12th. So we're gonna set him for, he has to appear on January 12th and sign his notice of setting, check in with the court's pretrial release officer. You're not gonna be required to be here because we're not set for trial. And then we'll work towards the special setting in August 31st. Does that make sense?
Yes, sir. Check it.
Good. I do show that he's delinquent $125 on his pretrial release fees. When's the last time you made a payment on that, Mr. McKeever?
I made a payment every month. They never, they went up. So I just paid.
Okay.
I didn't know I was.
Okay. Can you take care of that delinquency today? Okay. So when you get done, I want you to go over to the pretrial release office and cure your delinquency, and then we'll see you back on January 12th. Okay. When you come back on the 12th, you won't come back into the courtroom because we'll be picking a jury for a case for trial that day. My staff will be downstairs. Mr. West, the pretrial release officer, will be downstairs. They'll check you in, go through the paperwork, give you a reset, tell you when to come back. Okay. All right.
Your Honor, if I may, I believe there were a handful of motions that were filed by Mr. Bratton. I'm not quite certain how the court wants to handle ruling on those. Obviously, it would delay the trial if they weren't dealt with, I think, until
What
that
are
very
the
morning.
motions? Because no one's asked for a hearing.
Well, I think, Judge, if we talk about those, once those can be agreed to, should there be any that need to be contested, we can get in touch with the court. So, set up
Well, if they're gonna be contested, we should have already done that before we got to docket call, because I go arraignment, pre-trial, and then you tell me if there's an issue, we do contest it, and then we set it for docket call, so all that's done, so that once we announce we're ready for trial, we have nothing left but trial. So what are your motions? Are they contested motions like quash or suppress or anything of that nature that would be dispositive?
No,
An
they
issue?
should procedural type motions, Judge.
Like lemonies?
Limiting and,
Well, we'll carry those to trial. What else?
okay, and I think one is the election as to the punishment. I think there's some requests for exculpatory evidence when they come across it. It's just.
All those are automatic on my standing order
Right.
anyway. Yeah. Anything else?
No.
Okay, nothing out of the ordinary then.
No.
Okay, then we'll just carry.
Your Honor, there was a Jackson Deno motion on the voluntariness of the statements. That I don't think can just be, unless council thinks we can agree as to that. I think what my position would be is that they were all voluntary, despite the fact that he was in custody.
Do you need an evidentiary hearing on that, Mr. Bratton?
Well, we probably would need an evidentiary.
Yeah, so we need to do that before we get to trial.
Right.
So let's go ahead and set a hearing on that. Let's set that January 22nd. Thank you, Mr. Hernandez.
Yes, sir.
All right, so what I told you previously about January 12th, Mr. McKeever, you can forget that. We're gonna come back on January 22nd, and we'll have an evidentiary hearing over the voluntariness of the statements. And then we'll still leave him set for a jury selection on that August, what did I say, 31st? Okay. All right, so y'all be prepared to argue the motion that day, have any witnesses here that you need, and then the court will pass on that motion.
That would be 9.
Be 9 a.m. Yes, sir. And Mr. McKeever, once you pay your delinquencies, Ms. Clark is wanting to meet with you over there at her office. Yes. Okay. All right, we'll see everyone back January 22nd. All right, thank you, Mr. Brett.
And Your Honor, may I approach real quick?
Yes, sir. Stop.
Well, Ryan, they'll have one, but that one.
All right, for the record, files number CR 24222, CR 24223, State of Texas versus J. Snell. Mr. Quaid was set today. Status on Court of Criminal Appeals. Mr. Thorson had filed a motion for continuance, which was granted by the court. The court had Mr. Quaid sign a notice of appearance and issued him a new court date. The state has now filed motions to dismiss each case based on the Court of Criminal Appeals ruling in State v. Oregon, and the court, having reviewed the motion to dismiss, hereby dismisses each of Mr. Quaid's cases. So I've got those filed, and we'll send copies of those to Mr. Thorson.
Thank you, sir.
Thank you, Mr. Earl. Mr. Hall. All right, this is cause number CR 20-251, State versus Michael Carl Hall Jr. Mr. Hall, I have before me a request to extend your community supervision for 1 year. You were set to expire next week on the 10th, and you're asking to extend for a period of 1 year. And you understand that if the court grants this, you also have court costs and attorney fees. You have a balance on those. Is that why you're asking to extend it so you get those things paid off? Yes, sir. Okay. And it looks like the probation office is asking the court to allow your probation fees, UA fees to be waived, meaning you wouldn't incur additional costs. So to me, that sounds like they believe that you are doing really well on probation, except for the ability to pay, that you're otherwise compliant. Otherwise, they would be asking for probation fees and UA fees. So I commend you on that. Mr. Hall, has anybody threatened, forced, or pressured you to ask for an extension of your probationary period? All right, court will grant the amendment to the conditions of community supervision and extends Mr. Hall's period for an additional 1 year, beginning December 10th of 2025, ending December 9th, 2026. Mr. Hall, I've signed this. If you want to come over here and see Ms. Burns, we'll get a copy and then you're free to go. Mr. Schmidt, you ready?
Yes.
Who would you like first? Mr. Nunez. Mr. Nunez. This is cause number CR 25-184, State of Texas versus Sean David Nunez. Mr. Nunez, if you'll raise your right hand, I'm going to place you under oath. Other hand. Nope. It's all right. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes,
All right, you can lower your hand. Your name is Sean David Nunez, is that correct?
yes, sir.
Mr. Nunez, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
Do you understand everything that you've read and signed?
Yes, sir.
Do you have any questions about your plea agreement?
No, sir.
All right, Mr. Schmidt, do you believe Mr. Nunez to be competent to enter into a plea agreement? And if so, that he's doing so intentionally, knowingly, and voluntarily after having been apprised of his legal rights?
Yes, sir.
All right, Mr. Nunez, I see that you were originally charged with a second-degree felony offense of aggravated assault with a deadly weapon. I see that the plea agreement recommendation today is for you to plead guilty to a lesser included offense of a Class 8 misdemeanor assault causes bodily injury of a family member, which involves violence. The recommendation is for your punishment to be assessed at 1 year in the county jail, with that sentence being suspended, you being placed on 2 years of community supervision. They're recommending a fine of $1,000. You would also be responsible for court costs of $270 and reimbursement fees of $535. Mr. Nunez, is that your understanding of the plea agreement?
Yes, sir.
And that's what you're asking the court to approve?
Yes, sir.
All right, Mr. Nunez, the range of punishment for a Class A misdemeanor is up to a maximum 365 days in the county jail and a fine up to $4,000. I find today that the plea agreement fits within the lawful range of punishment. So, Mr. Nunez, how do you plead to assault causes bodily injury of a family member, a Class A misdemeanor?
Yes, sir.
And are you pleading guilty to that crime because you are, in fact, guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the admission of the evidence?
No, sir.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the state is in compliance with victim services. Victim indicated that she did not wish to participate in the prosecution of the case.
Thank you, Mr. Harwell. Anything further from the defense?
No, sir.
All right, court's going to review the evidence at this time. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement, the court hereby convicts Sean David Nunez of assault causes bodily injury of a family member, a Class 8 misdemeanor. The court assesses punishment at 1 year confinement in the Van Zandt County Jail. The court suspends that sentence today and places the defendant on community supervision for a period of 2 years. The court assesses a $1,000 fine, orders court costs of $270 and reimbursement fees of $535. Mr. Nunez, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come over to be fingerprinted. After that, you'll meet with the probation officers.
Okay.
So I just did the chase start.
Any updates? Still waiting.
Yes, Your Honor, I did hear from him. Whoever was bringing him the tire after I stepped out, they did arrive. He is about 45 minutes away once that tire is put on. I did inform him if he did not show up by 12, that his bond would be held insufficient.
Okay, right, if you would mind just waiting,
Yep,
you can see we'll get the business.
perfect. Thank you, Your Honor.
Merry Christmas, Brian. Merry Christmas. All front center right here.
Poking my head in to say Merry Christmas.
You're doing it loudly. Come on, right here, front center. Did you in the, we're on YouTube today. So bring it to. All right, I think you've been charged with bringing this chair. You look like you're guilty as hell. Guilty as hell. Or guilty as frost. Guilty as frost. How's it going? So, good. Merry Christmas. Merry Christmas. Appreciate you bringing that chair into the Van Zandt County Court. It's a criminal docket, but these are my favorite. Oh, yeah, these are great. Yeah, it's the tax cases. It's Hannah's fault. I don't think so. I think Hannah's what makes it right. She makes it bearable. So, good to see you. I don't think y'all can be about. Merry Christmas. Mr. Holland. This is cause number CR 20-291, Sanctions Court. All right, Mr. Holland, you're here for Sanctions Court today. You and I have had numerous conversations about your smoking marijuana while on probation. And it seems that you tested positive again at your last court session. That was sent off to the lab. So the probation department has asked the state to file a case and a warrant's been issued, and you're going to be taken into custody at this time. I understand. Sergeant Martinez, if you'll go ahead and take Mr. Holland into custody. Mr. Holland, once you get over there, we will set your case for a hearing on the motion to revoke. Mr. Holland, I'm going to set your motion on December 16th. Do you plan on hiring an attorney?
I will.
Okay, sure. So hire your attorney, have a good contact with the PA's office, and I'll set you on December 16th. If he's not ready, he or she's not ready, then just reset it to January. But I'm going to get you back in on the 16th. Okay?
Yes, sir.
All right. All right, court is going to stand in recess, allow Mr. Manning time to work with the state and his clients. It's probably going to be at least a minimum of 20 to 30 minutes. It's about quarter after. So just make sure you're checking in with your attorney, your bondsman, and court will be in recess for at least, let's say at least 30 minutes. So I'll be back at 10:45. Court's in recess. Okay, who are we ready on? Samir, are you ready? Mr. Alford?
Yes, sure.
Mr. Alford, come on up. All right, this is cause number CR 25-101, State versus Vincent Alford. We're set for pretrial. Any announcements, Ms. Mira?
We have worked out for prosecution. We provided the, proper documentation that they asked for.
Yes, Your Honor, if we could just get one more reset so I can look into all this, I think we'll be able to give the court a final resolution, probably before that reset. But just so I have time to match everything up.
Is this for negotiation on a resolution or is this discovery? Like, what is it you're talking about?
Resolving the case, Your Honor.
All right, so is there any need for any contested pretrial motions? Hearings?
No, Your Honor, it's our understanding that, once prosecution goes over the documentation, that the case will, come to a resolution.
All right, then the court will set Mr. Court will set, Mr. Alford then for docket call. Got 3 dates in January, 6th, 8th, and 20th.
20th, Your Honor.
Court sets Mr. Alford then for docket call, January 20th at 9 AM. Mr. Alford, when's the last time you made a payment on your pretrial release fees?
The one told me, somebody one.
What's to say? I didn't understand the word you said. What?
That's him or?
Yes, for the court.
The pretrial release. So you're on conditions of pretrial release that say that you have to make payments towards your bond supervision fee.
How much I need to pay?
He just has
Well,
to-
it's not, you've got conditions. You need to know what those are. It tells you in the conditions. You need to go see Mr. West and you need to
Yeah.
make a payment. It says you're $50 delinquent on your bond supervision fee. So that
Okay.
needs to get paid. It's not my job to tell you every time when you come in here what you pay, and where to go. That's your responsibility.
Yes, sir.
Understand?
Yes, sir.
All right, so I need you to get that paid today.
Yes, sir.
All right, we'll see you back on January 20th.
Can we be excused, Your Honor?
Yes, free to go.
See.
Mr. Manning, you ready on?
Start with
Mr. McLeod? This is cause number CR 25-98, State versus Shane Albert McLeod. We're set for docket call. Is this a plea today, Mr. Manning?
Yes, Judge.
Mr. McLeod, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Your name is Shane Albert McLeod, is that correct?
Yes, sir.
Mr. McLeod, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you have any questions about your plea papers or anything else regarding your plea agreement?
No, sir.
All right, Mr. Manning, do you believe Mr. McLeod to be competent to enter into a plea agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after having been informed of his legal rights?
Judge, I do believe he is competent and he is entering into this plea intentionally, knowingly, and voluntarily.
All right, the court sees that Mr. McLeod is indicted with a third-degree felony offense of evading arrest or detention with a vehicle which does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine, if imposed, not more than $10,000. I see the plea agreement in the case. Upon you pleading guilty, Mr. McLeod, the state's recommending that your punishment be assessed today at 10 years confinement in prison, with that sentence being suspended and you being placed on 5 years of community supervision. In addition, the recommendation is for the court to assess a $4,000 fine, for you to serve 11 days confinement in the county jail as a condition of community supervision, with you receiving credit towards those 11 days for time already spent in jail. And you are to serve February 26th, 27th, and 28th in the county jail as a condition of community supervision for every year that you are on probation. Mr. McLeod, is that your understanding of the plea agreement?
Yes, sir.
All right, and so at this time, I would ask you, how do you plead to evading arrest or detention with a vehicle?
Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
And Mr. McLeod, has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the admission of the evidence in this case?
No objection is offered.
All right, that is, evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything else from the state?
Nothing further, Your Honor. Thank you.
Anything else from the defense?
Nothing from defense.
All right, court's going to review the evidence. All right, court having reviewed the evidence. Counsel, will you approach? All right, and cause number CR 25-9A, State versus Shane Hilton. Court, if there's no objection from the state or defense, the board would request to transfer this to the county court of law for a conflict that the court has. Any objections from the defense?
No objections from the defense, Judge.
Any objections from the state?
No, Your Honor, thank you.
All right, board will, so what I'm gonna do is I'm gonna reset this to February 5th for docket call on my docket. And then inquire with the county court of law about them accepting the case. Once, if that's accepted, then the court, once it's scheduled down there, then we would just remove the February 5th docket call.
Yes, Judge.
All right, once he signs this notice, he's free to.
Thank you, Judge.
Thanks,
Judge, ready on Mr. James Arnold.
Mr. Arnold. This is cause number CR 25-117, State of Texas versus James Douglas Arnold, and we're set for docket.
Judge, Mr. Arnold has rejected the state's offer and requests a jury trial.
All right, what's the offer that's been extended and rejected?
Judge, I believe it was 5 years deferred, lifetime protective order, and $1,500 fine.
All right, and Mr. Arnold has been made aware that the court may not allow him to accept a plea agreement after the state.
Judge, I don't know if I advised him of that or not.
All right, I'll do it. Mr. Arnold, the court has given you time to determine whether or not you want to resolve this case by a plea agreement. And Mr. Manning has indicated today that you do not wish to accept the plea offer made by the state. So you requesting a jury trial, I'm going to place you on the court's docket for jury trial. If you change your mind later and want to accept a plea agreement, the court may not allow you to do that. The court may force you to go ahead with the jury trial that you've requested. You understand that fully, correct?
Yes,
Okay, and you understand that even if the state asked the court to allow you to do it, I may not allow you to accept a plea agreement.
I see.
Judge, he's hard of hearing.
Go ahead, tell him.
What Judge has told you is that he may not accept, if we have a deal that worked out in the future, he may not accept that deal and may require you to go forward with the jury selection that you've requested at this point. And that's whether the state urges that or whether we urge that, he may say, no, you've asked for a jury trial, I'm going to give you a jury trial.
Okay, yeah, understand.
You understand, Judge?
All right, and I also see that Mr. Arnold is $390 delinquent on his pretrial release fees. Why are we so delinquent?
What's that?
He says you're delinquent on your pretrial release fees. Judge, Mr. Arnold paid those in full on
Today.
12/4, and we have a receipt, $480 paid.
All right. All right, so Mr. Arnold, you need to be paying that monthly. You don't need to be paying that after you become delinquent. You need to pay that monthly.
Yes, sir.
You understand? All right, court will place Mr. Arnold on the jury selection docket. We'll begin that on Monday, January 12th. So Mr. Manning, if you can just explain to Mr. Arnold when you get a chance that he'll appear downstairs, meet with my staff, meet with the pretrial release officer, and that you may not be there until his case is in the top 10.
Yes, Judge, I have explained that to him in the hallway.
All right, thank you, sir.
Yeah, you gotta show up. Just a sign, get reset.
Okay.
All right, who's next?
Judge, next, Mr. Martin White.
Mr. White? All right, this is cause number CR 25-148, CR 25-149, State of Texas versus Martin Lee White. See that we're set for docket call.
Judge, Mr. White rejects the offer made on this case and requests to be set on jury selection.
All right, what's the offer that was extended and rejected?
3 years TDCJ.
3 years TDCJ. And did he have any credit towards that time?
Your Honor, I'm sure there was, but we didn't calculate it.
All right, and Mr. White is clear that the court may not allow him to accept this offer or any other offer after today.
Yes, certificate's coming too.
All right, court places Mr. White on jury selection January 12th, each case. Mr. White, you'll report downstairs and meet with my staff on that day. Mr. Manning will not be required to be here, but your case gets in the top 10. Well, once it gets in the top 10, then I'll notify him, okay?
Yes, sir.
And show that you're delinquent $80 on your pretrial release fees. When's the last time you made a payment?
I haven't made one yet, but I can have it paid in full by the 12th.
Oh, by the 12th? Well, that's gonna be a problem because you're gonna get new bond supervision, you're gonna get new attorney fee. You're gonna have new fees due in January.
Yeah, I'll be able to pay those also.
So you'll be able to pay $160 in
Yeah.
January?
Yes, sir.
All right,
Yes,
court's gonna order you to have $160 paid on towards your pretrial release fees by January 12th. If you don't, court may bring you back for a hearing on your pretrial release.
Okay.
All right, once you sign your notice, you're free to go.
Thank you.
All right, who's next?
Judge, next we have Mr. Pate.
Mr. Pate. Court call CR 25-83 State versus Eddie N.R. Pate.
And I'm sorry, we can report one more time.
Yes. All right, this is cause number CR 25-83. Mr. Pate, you are charged by indictment with burglary of habitation and other felony, first degree felony. The state has filed a motion to dismiss today indicating that insufficient evidence offense beyond reasonable doubt. We're just granting the state's motion to dismiss. Free to go.
Awesome. Thank you. Thank you.
All right, this is State of Texas versus Patrick Ray Rowe, cause numbers CR 23-116 and 117. Mr. Rowe, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, your name is Patrick Ray Rowe, is that correct?
Yes.
And Mr. Rowe, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes.
Do you understand everything that you've read and reviewed that's part of your plea agreement?
Yes.
Do you have any questions about the paperwork or anything else?
No, sir.
Not for,
Not what?
Judge, there were things that we discussed that he did have questions about. Some of those are only going to be able to answer by Mrs. Clark, his probation officer. But I did answer all the questions that he had regarding the conditions of probation, impact of his waiver of rights to this plea.
Do we need to pause and let him speak with Ms. Clark to find out if that's going to be an issue that would make his plea involuntary if he gets over there and decides that's not what he signed up for?
Judge, it was in regards to his employment, and he's let me know that he would just change his job if that impact. It was in regards to travel, his ability to travel with his employment. He has talked to Ms. Clark about that previously, but he just wanted to make sure that was still okay. Him being able to travel with his job, as these conditions require him to remain in Van Zandt County.
Okay. And would that travel be outside the state?
No, Judge.
Okay.
It's just been the state of Texas.
Okay. All right, so Mr. Manning, do you believe Mr. Rowe to be competent today to enter into a plea agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after having been fully informed of his legal rights?
Judge, I do believe he is entering into this plea intentionally, knowingly, voluntarily, and he is competent to make this plea.
All right, Mr. Rowe, you are charged with two crimes: a sexual assault of a child, a second-degree felony, and online solicitation of a minor, a third-degree felony. I see that there is a plea agreement today wherein the DA's office is recommending to the court that you be prosecuted on the online solicitation of a minor. Their recommendation on that case is for the court to consider the evidence and to defer a finding of guilt, placing you on community supervision for 8 years, you being assessed a fine of $2,000, court costs of $290, reimbursement fees of $580. And in addition, the state would be agreeing to dismiss the sexual assault of a child charge, which is CR 23-116. As part of this plea agreement, it would require you to register as a sex offender according to Chapter 62 of the Texas Code of Criminal Procedure. Is that your understanding of the plea agreement and what you are also asking the court to approve?
Yes.
All right, Mr. Rowe, the range of punishment for a third-degree felony offense is not less than 2 years in prison or more than 10 years in prison, and a possible fine not to exceed $10,000. Should the court accept this plea agreement today, and the court placed you on deferred community supervision, the court would order you to comply with certain terms and conditions as part of that community supervision. If you violate any of those, the state could file a motion to adjudicate your guilt, which means motion to find you guilty. The state could then put on evidence, and if the state proves to the court that you violated any term of your community supervision, the court could do a number of things, including convicting you of the offense and assessing your punishment in prison anywhere from the minimum 2 years all the way up to the maximum of 10 years. Do you understand that?
Yes.
In understanding those things, you still wish to go forward, correct?
Yes.
All right, so Mr. Rowe, how do you plead to online solicitation of a minor, a third-degree felony?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime? And has anyone threatened you, forced you, or pressured you to plead guilty?
No.
All right, the court will accept the defendant's plea of guilt as to that charge. Mr. Manning, any objection to the stipulation of evidence being admitted?
No objection as offered.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. State, can you address the victim notification and participation in the case?
Yes, Your Honor. She was actually on board once she was served with subpoena and very cooperative. She paid several visits to our office in preparation for trial. We have thoroughly advised her of the plea that was negotiated with Mr. Rowe. She was in 100% agreement and has asked the court to accept the plea and is also in agreement with dismissal of the sex assault charge.
All right, and she was a minor at the time that the offenses were alleged to have been committed. Is she a minor at this time?
No longer, Your Honor. She's over the age of 18.
Okay, and the state is recommending this to the court as being in the best interest of the defendant and the community, including the victim.
Yes, Your Honor.
Okay, anything further from the defense?
Nothing from defense judge.
All right, and the court does take judicial notice of the sexual interest assessment that was performed on Mr. Rowe. Court is having that filed with the clerk to be included in the case. The court's taking judicial notice of that. Based on the information contained in the evaluation and the recommendation from the DA's office and the request of the alleged victim in this cause, the court will follow the plea agreement today. The court, having reviewed the stipulation of evidence, finds that there is enough information and evidence to convict the defendant of online solicitation of a minor. The court hereby defers a finding of guilt, places the defendant on 8 years community supervision, orders him to pay a $2,000 fine, $290 court cost, $580 reimbursement fees. And the court notates that as part of the plea agreement, the state is agreeing to dismiss and has in fact filed a request to dismiss cause number CR 23-116 as part of the plea in this case and at the victim's request. Mr. Rowe, you hereby remanded. Well, let me say further. Court finds that Mr. Rowe, having been prosecuted for an online solicitation of a minor, finds that this charge is subject to Chapter 62 of the Texas Code of Criminal Procedure. Court finds that the age of the victim at the time of offense was 15 years old, and the court orders him to comply with sex offender registration as required by Chapter 62 of the Texas Code of Criminal Procedure. The court finds that a copy of Chapter 62 has been provided to the defendant in this case. So, Mr. Rowe, you're hereby remanded to the custody of the Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. After that, you'll meet with the probation officers. Yes, I got a question too. Let's,
Hang on just a moment.
Court is on record in file number CR 25-6, state of Texas versus Miranda. Yeah. It's back. Paid by the court for violation. It's had since. Some type of supervision with substance. Issue. It's had. Violation. It's her bill, sufficient. Set new bill, $1,000. Set his hat.
Just to went to the 16th, I believe we have docket.
State's comfortable with that, Your Honor.
Set his hat.